We're going to wrap up pretty soon, but before we do that, I do want to take one final opportunity to thank our sponsors. The gold sponsor, the Consulate General of Canada in Detroit. Colin, thank you very much. Silver sponsors, Blake Castles Graydon, Pile Dynamics, and GRL Engineers. Bronze sponsors, Baker Hostetler, Barrett America, Formica Corporation, Richard Newcomb, Richard W. Pogue, the Government of Quebec in the Chicago office, and Taft Stettinius. And finally, our community sponsors, the Cleveland Council on World Affairs, the Council of the Great Lakes Region, the Greater Cleveland International Lawyers Group, the Northern Ohio District Export Council, Ohio Aerospace Institute, the Wilson Center through its Canada Institute. And finally, I want to give a special thanks to special people who worked very hard to put this together, particularly Eric Seiler. Eric, if you're out there, wave your hand. And also Steve Paley, our managing director. And so we're now here at the time. We've heard a lot. We've learned a lot. We realize there are many challenges facing us with respect to the enforcement and promotion of human rights. And we need some help to assimilate this. So our Canadian National Director, Kai Carmody, is going to give us some perspectives and thoughts. Kai's an associate professor, but soon to be full professor at the University of Western Ontario's Faculty of Law. He teaches public international law, international trade law, and international business transactions. And he's been a visiting professor at Georgetown and NYU and many other distinguished institutions. Kai's a noted expert and highly published on legal issues concerning international trade, climate change, and Canada-U.S. relations. In fact, Kai's latest book on the World Trade Organization has just been published and released. So Kai, over to you to help us figure out what we've learned today.
Steve, thank you very much for those kind remarks. I know that I'm the last speaker of the day, at least formally, so I'll try to keep these remarks short and sweet. For those of you I haven't already met, my name is Kai Carmody, and I'm an associate professor at the University of Western Ontario Faculty of Law. I've been the Canadian National Director of the Institute since 2002. I've been coming to this annual conference annually since I began my teaching career in 1999, and I've always been impressed with the level of involvement that the conference has garnered. In the early years, as we heard last night, the proceedings were stewarded by the indomitable Professor Henry King Jr., who made this conference an annual event, his life's work. The tale is often told by Dan Utso of the way in which Henry insisted on Sunday morning concluding sessions. Yes, he did. And would wake the following Monday morning to begin pestering and badgering friends and acquaintances from many walks of life across North America to attend the following year's conference. Henry's strident bell ringing wasn't the only thing that he was insistent about. From his time at the Nuremberg trial, Henry was passionately committed to human rights. The memory of Henry and so many others who no longer attend or have passed on is a reminder to me of the way in which each of our individual contributions matters in life and in the protection of international human rights. References to the late Michael Robinson and to my own memories of another leader and former dean here at Case Western Reserve University School of Law for many years, Peter Gerhardt, are proof of that fact. The fact that we're prepared to take individual responsibility and to say no or yes to certain practices or to insist on international minimum standards of protections lie at the core of international human rights, of ways in which we demand and have a right to live. Very evidently, there are practices that we no longer contemplate or consider acceptable, like the subordination of women, racist behavior, or the demeaning of Indigenous peoples and peoples with disabilities. Our world has changed in ways that our ancestors could hardly imagine. And yet, at the same time, What makes living today so trying and so disappointing is that in a number of prominent instances, like Russia's illegal aggression in Ukraine, the conflict in Israel and Gaza, civil wars in Yemen and Sudan, the situation in Haiti, that change is being held up and under threat. We have reason, as our lunchtime speaker Isha Khan noted, to doubt the frameworks of human rights protections. We feel a need to step outside them, to understand others, and as she pointed out, to try to trust. The annual conference this year began with a rousing opening speech by Dean Michael Scharf, where he counted and recounted the ways in which Case Western law faculty and students have so often been at the forefront of developing international human rights protections. Dean Scharf referred to the Universal Declaration of Human Rights of 1948, which we celebrate the 75th anniversary of this year, and its immediate progeny, the ICCPR and the ICESCR of 1966, and the way that these documents have altered what governments are allowed to do to their citizens and to others. They represent a critical paradigm shift. Still, they cannot be taken for granted. On so many occasions in today's proceedings, it was evident how securing international human rights requires constant work and rework. The job of realizing the high ideals of the Declaration and of their concretization in binding instruments like the ICCPR and the ICESCR is a continuing one that individuals must be committed to regardless of the prevailing political climate. Our conference proceedings today began this morning with an address by Consul General Colin Bird. Colin told us, or spoke to us, describing the growing emphasis in international economic relations on human rights in the last few years. To counter the perceived race to the bottom that appears to be unfolding in international economic law, that body of law has started to change. We heard about the USMCA's rapid response mechanism, about the Canadian government's efforts to mandate reporting of forced labor in supply chains, and about efforts to include, empower, and assert Indigenous peoples in the context of international trade. Our first panel, Approaches to Advancing Human Rights, reminded us that Canada and the United States have been involved in the promotion of international human rights from day one. However, when we look back on their own human rights obligations, it turns out to be a mixed bag. The strong commitments and high-flown language of documents like the Universal Declaration did not stop the deportation of the Japanese Canadians and Americans in and after World War II, the 60s scoop of Indigenous children in Canada and the United States, the detentions at Guantanamo Bay that took place in the last 2.5 decades. Avidan Cover provided a masterful overview of the way in which U.S. human rights protections do not necessarily fulfill international minimums. And in contrast, while Sarah Gebremoose pointed out that Canada is doing a relatively good job in protecting core human rights, much of that protection is assimilated to existing constitutional law protections. The problem here, however, is that constitutions can be straitjackets and covers for behavior that are ultimately unacceptable. I think a very good example of that covering is the fact that Canada's Indigenous people have long asserted that the vague language of Section 35 of Canada's Charter of Rights and Freedoms is unsatisfactory. This is the provision that alludes to Indigenous rights and their protection under the Constitution. If Canada's constitutional protection of Indigenous peoples was enough, a constitution that came into full effect only in 1985, why did it take UNDRIP in 2007 and beyond to get movement on so many issues of interest to Indigenous people for initiatives like clean drinking water in banned areas, or reparations for the experience of Indigenous children in residential schools, or the content of an UNDRIP-identified duty to seek free, prior, and informed consent by Indigenous peoples in matters affecting them. These issues suggest that domestic constitutional law is not always enough to meet international minimum human rights concerns, and that international law itself, as external to the state, can serve an important tool to help guide the attainment of progressive change. Brian Gran also hinted to us that common denominators of human rights abuse include a lack of respect for basic humanity, for human dignity, racism, and xenophobia. Basic disregard for people as people may be a hallmark of what we are seeking not to do. In our second panel today, Protecting Human Rights Through Economic Sanctions and Supply Chain Due Diligence, we heard from Richard Newcomb and John Boscariol, our two of the best panel, who told us about ways in which sanctions are a robust response to a range of threats or existing situations that are considered inimical to U.S. interests. Despite their success, sometimes checkered, sometimes more successful, however, we see some doubts about this record of sanctions applications and questions about what could be done to plurilateralize these efforts and these instruments. In Canada, we've been tough on paper with respect to sanctions. At the same time, we heard that process and enforcement issues have been poor. Some of this poverty is no doubt due to the novelty and the scale of what is required, as well as capacitation and the pronounced need for a change in mindset. The criminal law standard that currently applies in Canada with respect to sanctions matters is generally a high one. We need, as in the United States, civil, criminal, administrative, and other enforcement tools to really get at the problem and make sure that these sanctions are effective. And obviously, better cooperation and coordination with the United States and other like-minded partners could go some way to achieving these aims. In our sessions at lunch and our lunchtime speaker, Isha Khan, we heard about Indigenous approaches to empowerment and reconciliation. After lunch, Winona Singel detailed the way in which seminal U.S. Supreme Court decisions have dispossessed, disenfranchised, and disempowered Indigenous people and resulted in severe intergenerational trauma. We also heard, in a somewhat more hopeful vein, from Wayne Garnon-Williams about the Indigenous Peoples Economic and Trade Cooperation Arrangement and its principles of Indigenous trade, environmental sustainability, and an Indigenous perspective on trade. Nevertheless, Wayne also reminded us how previous efforts to deal with Canada's residential schools legacy has resulted in a lottery's curse that has had little lasting benefit for Canada's Indigenous people. And this example is a cautionary tale to others that other efforts that might be made to address the human rights claims of Indigenous people and others purely by economic means. In our final panel this afternoon on climate change and human rights, we heard from Sonia Savage, Christy Balsanic, and Professor Victor Flatt. Sonia detailed the difficulties of implementing a net zero climate change plan in a jurisdiction that required careful consideration of balance. The major question was, can we get to net zero? And as Alberta's Minister of the Environment, Sonia answered that question in the affirmative, but decided against interim targets or binding legislation. Instead, what was necessary, in her view, was principles and guardrails. Christy went on to a fascinating discussion of the U.S. perspective on climate change and human rights. She detailed the way in which the Biden administration has pursued a ambitious 50% GHG reduction from 2005 levels by 2030. She also described the way in which the EPA is developing the concept of environmental justice, something that's going to be very interesting in years to come. While at the state level, she noted that unfortunately there's a patchwork approach of different initiatives, and that at the other end, an anti-ESG movement and a state SEC rule on climate-related risk disclosure displays something of a counter trend. For companies that are trying to swim in such tricky currents, Christie suggested the need for companies and boards to align standards with company-specific priorities. In the meantime, litigation like Held versus the state of Montana that Christie referred to may force hands to act pursuant to a state right to a clean environment. All of the above is very hard to tie together and to try to trace to a common thread that we might agree is called human rights. However, last night, as I walked back to my hotel, I saw two plaques that I thought were opposite to what I might have to say today. One of these was a simple quote on a bench next to the Guilford House here on the Case Western campus, which contains the inscription, "To do what is right, do what is human." The quote is attributed to Kazuo Inamori, founder of Kyocera Corporation. Inamori founded Kyocera in 1959, and today the company is an international giant supplying a wide range of communications and other electronic products. Through Kyocera's generosity, the Inamori Center for Ethics and Excellence at Case Western was established in 2007. A few steps later, across Euclid Avenue, as I was making my way back to my hotel in the dusk, I saw a historic plaque labeled Fields of Ideals next to the Allen Memorial Medical Library that recounted how near that site in the 1840s stood the home of Horatio and Martha Ford. According to interviews conducted in the 1890s, the Ford's house was a stop on the Underground Railway. In the 1840s, the couple regularly helped move fugitives to the Cleveland docks, where a freed African-American, John Brown, arranged for their passage across the lake to freedom in Canada. My point is that it is important not only to act on ideas, but on ideals. If we do not have and hold steadfast to ideals, it's difficult to fashion a better world. In their many comments today, it appeared to me that many commentators seem to agree. The world is a messy place, as Isha Khan noted to us during her lunchtime remarks. At the same time, part of the problem may be the way we think about things. In the sphere of human rights protections, sometimes we have to remember to listen, not to speak. Sometimes we have to remember to hear, not to respond. And sometimes we have to learn not to insist on being right, but to sit in the uncomfortable place of realizing that we and others may be wrong. This is difficult work, and it is the difficult work of human rights. In closing, I'd like to thank our sponsors, which Steve Petrus has already done very skillfully. I'd also like to extend a particular thanks to Eric Siller, who has also been thanked already by Steve, to my fellow Institute National Director, Steve, of course, and his lovely wife, Colleen Fitzpatrick Petrus, who joins us here today, and especially to the Institute's Resolute Program Director, Steve Payet, as well as our Managing Director, Ted Paran. The Steves have worked very hard over the last few months to put this conference together, and they continue, as always, to do so with great efficiency, imagination, and verve in this inspiring venue, the Cleveland Botanical Garden, at this most lovely time of year. So thank you very much, everyone. Merci beaucoup, as Monsieur le Délégué Jean-François Houault would have said. Safe home, and we look forward to seeing you next April 10th and 11th, 2025, here in Cleveland for the 49th Annual CUSLI Conference. Thank you.